Hi, a quick note before we get started. Minimum Competence now offers CLE courses. Our first course is live and it's completely free. It covers researching federal tax issues after the Supreme Court's decision in Loper Bright, including how the end of Chevron deference changes the way lawyers should approach Treasury regulations, IRS guidance, and tax research more generally. I think it's interesting for a more broad audience, and if you need CLE credit or you're just interested in the topic, head over to cle.minimumcomp.com. Again, the course is free, and you can find it at cle.minimumcomp.com. All right, on to today's episode. Hello and welcome to the Minimum Competence episode for Wednesday, August 26th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, the White House says its Kennedy Center signage doesn't violate a judge's order. Deloitte pays $21.5 million over its DEI programs, and an appeals court blocks ideological conditions on homelessness grants. Let's remember, one is born and remains free and equal in rights. And read today's legal news. On this day in legal history, August 26, 1789, France's National Assembly adopted the Declaration of the Rights of Man and of the Citizen, one of the foundational documents of modern constitutional government. The Marquis de Lafayette played a major role in drafting it with input from his friend Thomas Jefferson. I don't know if you've ever heard of him, who was then serving as the American minister in Paris. In just 17 articles, the Declaration tried to turn Enlightenment ideas about natural rights and legitimate government into law. A lot of it will sound familiar to American ears, in part because the American and French revolutions were very much in conversation with each other. Article 1 declares that, quote, men are born and remain free and equal in rights. Obviously using some gendered language there. That's also today's opening quote, reworked a little bit for our modern ears. The Declaration identifies liberty, property, and security, as well as resistance to oppression as natural rights. It says the law must apply equally, punishment must be authorized by law, defendants are presumed innocent, and the free communication of ideas is, quote, one of the most precious of the rights of man. It also makes separation of powers part of the definition of constitutional government. A society where rights are not secured and powers are not separated, quote, has no constitution at all. The Declaration mattered well beyond France. Its ideas influenced constitutions throughout Europe and Latin America, and eventually found echoes in the Universal Declaration of Human Rights in 1948. There was also an enormous gap between the Declaration's promises and what followed. Within a few years, the French Revolution had descended into the Terror, and the supposedly universal rights announced in 1789 were plainly not being extended to everyone. That makes August 26th an especially fitting date for another reason. In the United States, it's Women's Equality Day, commemorating the 1920 certification of the 19th Amendment. The coincidence is a useful reminder that declaring people, quote, equal in rights is considerably easier than actually making them so, and that many of the people supposedly covered by universal declarations of equality had to spend generations fighting to make those words actually apply to them. A federal judge previously issued an injunction barring the administration from renaming the Kennedy Center for the Performing Arts after President Trump. Then, earlier this month, the Kennedy Center's board, now dominated by Trump toadies, voted 20-3 to change the building's signage to read, the John F. Kennedy Center for the Performing Arts, restored and renovated by President Donald J. Trump, and to name the surrounding grounds President Donald J. Trump Plaza. The administration's argument in a new filing is essentially semantic. It says this doesn't violate the injunction because the building is still named the John F. Kennedy Center, and the added inscription is merely a donor acknowledgement, the kind, it says, that's ubiquitous in similar facilities. Democratic Congresswoman Joyce Beatty, who's part of the suit, says the board openly defied the court's ruling and has asked the judge to block the signage. Here's the legal question, and it is actually a real one. When does creative compliance with a court order become defiance of it? Courts don't just police the literal words of an injunction, they police attempts to accomplish the forbidden thing through a technical workaround. If the injunction's purpose was to stop the center from being turned into a monument to the sitting president, a judge may well look past the "we didn't technically rename it" framing to the practical reality. The judge, Christopher Cooper, has set a fast briefing schedule with deadlines today. The significance is that this small, almost absurd, no, actually absurd, dispute over building signage is really a test of something fundamental. Whether the executive branch will comply with a court order in substance or look for the narrowest possible reading to get what it wanted anyway. Deloitte has agreed to pay $21.5 million to settle Justice Department allegations that its diversity, equity, and inclusion programs amounted to illegal discrimination, a landmark in the administration's campaign against corporate DEI. Note the legal vehicle because it's clever and aggressive. The DOJ brought this under the False Claims Act, the federal government's primary anti-fraud statute. The theory is that Deloitte, as a federal contractor, certified compliance with anti-discrimination requirements while allegedly running DEI programs that themselves discriminated. Note, against white people, making its certifications false. The specific allegations are that Deloitte's business units received monthly summaries tracking progress against, quote, demographic goals. Roughly 150 senior partners and managing directors had parts of their compensation tied to hitting those targets, some risking tens of thousands of dollars. And race and sex were allegedly factored into promotion decisions and access to certain training and mentoring programs. Of the $21.5 million, about $10 million is designated as restitution. Crucially, Deloitte denies the allegations, and the settlement includes no admission of liability. The significance is that this reframes DEI from a corporate HR initiative into potential fraud against the United States itself. We've tracked the administration's use of Title VI against universities, Harvard, Columbia, William and Mary, and this is the corporate front of the same campaign, deploying the False Claims Act against a major government contractor, Deloitte. That is a powerful deterrent because the False Claims Act carries treble damages, that's triple damages, and invites whistleblower suits. Whatever you think of DEI programs on the merits, the legal move here is significant. It puts every federal contractor on notice that diversity targets tied to pay and promotion could be recast as discriminatory, and therefore, as a false certification, the government can prosecute. And finally, a federal appeals court has ruled that the administration cannot attach ideological conditions to federal grants for homelessness and transportation, another entry in the running saga over the limits of the executive's power over the money. The Ninth Circuit, in a decision backing Santa Clara County and other local governments, affirmed a lower court and found that the administration abused its authority by imposing new strings on grants like the Continuum of Care program, which has funded homelessness services since 1987. Those grants have long been built around a housing first philosophy, the approach of getting people into permanent housing without preconditions like sobriety or employment. And the administration sought to attach conditions, cutting against that model and advancing its own policy priorities. The court found that cities would suffer irreparable harm if the funds were withheld. The legal principle, and longtime listeners will recognize it, is that back in July, we covered the anniversary of South Dakota v. Dole, the case that lets the federal government attach strings to the money it gives states, but only within some limits. The conditions have to be clearly stated, related to the purpose of the funding, and not coercive. When an administration tries to bolt novel ideological conditions onto grants Congress created for a specific purpose, like homelessness, courts have repeatedly said that exceeds those limits. This fits a pattern we followed all summer, from the OMB grant clawbacks to the EPA's frozen climate funds, of courts telling the executive, the president, that money Congress appropriated for a purpose can't be turned into a lever for unrelated policy goals. The significance is that the spending power, real as it is, keeps running into the same wall. You can fund homelessness programs or not, but you can't quietly rewrite what they're for. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow. And until then, remember, the law must be the same for all, whether it protects or punishes.